Begin with today's Minnesota Landlord Tenant Law Essentials, New and Old Rights and Responsibilities in Minnesota. I first want to remind you that rental properties, you can list your openings for free on housinglink.org. We get over 1 million searches a year for housing, and it's for folks looking for affordable housing as well as those who they don't have any subsidy, they don't have any rental assistance, they're just looking for a place that fits within their budget. And so if that's you, go ahead and give the Housing Link website a try. And I also just want to give everybody a heads up that Housing Link is in the process of redesigning our website. I just want to give you a very brief preview of this as well so that you can see what it currently looks like. So many of you are familiar with this being our current website. And let's say you're a property owner or manager and you want to get education and you click on it and it's functional but pretty ugly, right? I would say so. So what we are doing is changing it to be something that is more user-friendly, easier to find the content that you are looking for, and something that is more visually appealing as well. And so here's a preview of what is to come on the Housing Link website. We'll have content, easy to find content for renters, owners, and managers, some of the different services that people rely on, resources targeted particularly to renters as well as owners and managers, making it much easier to find. And if you take a look at that education page in comparison, well, now we have something that looks like it was designed post at least 2020, I would say. So anyway, we're redesigning our website. It's probably going to launch new in the next 30 to 45 days. So just prepare yourself for that. If you could pick your jaws up off the floor, as excited as I imagine you all are now, that might help you focus on the rest of today's training. Okay, so let us now dig in. So one thing, where to see Minnesota landlord tenant law? One of my favorite places to go for it is the actual page on the page on the internet that has just the raw law language. So that is this link. You all will get a copy of these slides after today's training. So if you are writing notes and you miss something, fear not, you will get a copy of this. But yes, there are news outlets that provide some summaries of things. There are even like the landlord tenant law rights and responsibilities brochure, which is great. But I like to go right to the website, and so you probably are able to even copy that link in that Mentimeter section over there and put it into a tab so you can see what I'm talking about, because that's where I like to go to see what does the law actually say, not what somebody summarized it to be. So the first thing we're going to talk about is the notice of eviction. This is one of the big changes that took place in terms of new laws that were passed in the 2023 legislative session that are in effect now. So related to notice of eviction, let's first start with one of our live polls, which is how much notice are rental properties now required to give renters before filing an eviction? So answer this in that Mentimeter section to the right. Are they required by state law to give no notice? So non-payment of rent, they can just go right away and no notice. Is it 7 days, 14 days, 30 days? Want to remind people of a few things. We've got kind of a broad cross-section of people attending today's training. We've got a lot of rental property owners and managers, but we also have a lot of agencies that serve renters. So we're all going to be here for common language in a community learning experience, we will call it. So yes, and just note that today's training is scheduled for 90 minutes. That's the absolute maximum. We may end early. We may end a lot early, depending on your questions and comments throughout our time together today, but we will cover everything that we came to cover. I assure you of that, but don't be surprised if you have a little bonus time after today's training. So we are seeing a bit of a consensus here. One person says 7 days, 30 of you say 14 days, 19 of you say 30 days. What is it? The correct answer here, my friends, is 14 days. However, some local jurisdictions may pass their own laws that are longer. For example, it hasn't gone into effect yet, but the city of St. Louis Park is currently deliberating whether or not they want to require properties to provide a 30-day notice to renters before filing an eviction in the case of non-payment of rent. Let's be specific here. This is about in the case of non-payment of rent, not if there's some sort of breach the lease that would jeopardize safety or something along those. Those do not require the 14-day notice. But if we're talking what is encompasses over 90% of evictions in the state of Minnesota, which is non-payment of rent, it is 14 days. But make sure to pay attention to your local jurisdiction's rules around this. But generally, this is where it falls as of right now. So 14 days. So that means if the renter does not pay the rent, and in the past, you would just, as a property, you would go out and file an eviction because before you just go right out and file right away. Now you have to provide a written notice that in 14 days you are going to do that. But let's dig into another poll question related to this. And this one is only if you are a property owner or manager, I'd like you to answer it. I can't control what you do. But what I want to know is if you're an owner or manager of rental property, if you're on the landlord side of things, before this new law, how long would you usually wait before filing an eviction for non-payment of rent? Was it 0 to 7 days, a few weeks, or a month or more? And this is, I'm just kind of doing this out of curiosity. Or if you are somebody who's on the renter side of things, you could answer this in terms of what did you see as well? What did you see folks do? Would they let people kind of give them a little extra time, a few weeks, a month or more, or would they go right out and file it right away? Just kind of see where we're at here. Because I've worked in this industry or really close to this industry for a long time now, really since about 2006, either working in it or close to it. That's an alarming 18 years. And one thing I've noticed is pretty common is that, let's say the rent is due on the first of the month, and then people get a grace period of maybe 3 to 5 days to pay it. After the grace period, the late fee kicks in, which is a maximum of 8% of the unpaid rent amount. And then after that, a couple of weeks might go by and then a property may move forward. But you're seeing here that you've got quite the cross section of things that used to take place. But the majority would give a few weeks or a month or more. I always like to think about these things in light of what impact will a new law have on a renter's experience, if any. And that's why I kind of like to just get a sense of what people did before. Thank you for answering that. And so now I want to know what you plan to do now. So this one really is only for the rental properties. How long, now that this new law is in effect, will you wait to send renters the notice of intent to file an eviction for non-payment? So this is about the 14-day notice is now required. Now that that 14-day notice is required, what is your plan as a property for sending that notice? So are you going to kind of give a similar amount of time as you gave before, a few weeks or a month before filing, or how will this new law change your behavior, if at all? That's what we're looking to see. And this is all totally anonymous, just to get a sense of how people might be responding. So there was a comment that came in just related to when might somebody go ahead and file an eviction. And this is a property that wrote in and said, if the renter is in communication, they'll give more time. So if the renter's like, I'm behind on the rent, I'm working on it, I'm trying to access emergency assistance, I'm trying to get this sorted out, then the landlord would give more time. But if the renter is not communicating at all, if the renter is not engaged in the process, then they might go file sooner. And so if you are a case manager or somebody who advocates on behalf of renters or serves renters, that's a really important point, is that how a landlord sort of interacts with the law can depend on what kind of communication happens in the process. They might give more time if communication is really responsive, clear, and transparent. Or if there is no communication, they might move more quickly. All right, we'll give this a few more moments to see if any other properties are plan on responding to this particular question, and then we'll. And I like to see this because this will be can be a really informative to those who are serving renters and trying to help in terms of before. Let's just go back here. So before, and this is just among the people participating in this training. And we're not going to call this a representative sample. We'll just call it anecdotal. But, previously we saw that at least the majority of places were going to give a few weeks or a month or more. Now that the 14-day notice is required, we're seeing folks might act a little bit sooner. So that means if I'm a case manager serving a renter and I know that non-payment of rent might be an issue, we're going to have to be really working on accessing resources and acting faster maybe than we had to before, potentially. All going to vary and be very dependent on the individual property that someone is in. But this is just would be something you want to have in mind if you are serving renters, that we're going to be really organized and communicate really clearly and do everything we can to get that rent paid so that the property doesn't move forward with, well, A, giving us that notice, and B, filing the eviction. But keep in mind that notice of intent to file an eviction is, you have all that time before the eviction is filed, so that 14 days, so to speak, or maybe 0 to 7 days here, plus 14, that's sort of your window of time to work it out. And know that one thing that will be a bit more helpful in some instances is that notice of intent to file an eviction is enough to trigger emergency assistance. So before, in a lot of cases, it was kind of a dilemma. The landlord actually had to file the eviction, and then that filing is what would trigger the ability to access emergency assistance for the renter. So now, one thing that'll be really nice, and particularly in terms of a renter's background, is this notice that the landlord gives. This notice, this 14-day note, will be enough to get the emergency assistance ball rolling on behalf of the renter. So just know that is there. And thank you so much for answering the question. Now, the rental property, it has to be a written 14-day eviction notice. Text and email do not count in this case, I believe. And it must be delivered personally or by first class mail. Okay, so it's a written 14-day eviction notice, and it must be delivered personally by first class mail. Actually, I have not heard an opinion on if text counts or if email counts, but if I was a property, I'd want to stick pretty closely to this because, as you know, if you move forward with the process and they say, all right, they didn't follow this process correctly, then it's going to restart the clock in terms of the process of the eviction filing. You have to give the 14-day notice again. So go with a professional letter that's written, that's delivered in the mail or delivered personally so that you are following the processes as outlined. So there are things that are required in the 14-day notice for it to be a valid or following the law notice, and that is the total amount due. So between rent, utilities, fees, everything that has caused the renter to be behind, they need to see that number in the notice. Also, you got to break it down. There's got to be a specific accounting of the amount of the total due of unpaid rent, late fees, and other charges under the lease. So it'd be, let's say, $1,000 unpaid rent, $200 unpaid utilities, $50, damage to the doorknob, whatever it might be, so that they know the breakdown of what the unpaid charges are as well. So a total amount, as well as a specific accounting of what led up to that total amount. Also in the letter, it has to have the name and address of the person authorized to receive rent and fees on behalf of the landlord. Gosh, I hate legal language. What that is if you are the landlord, let's say you are the property owner and it's just you, then you're going to have your name and contact information in that letter. If you are a management company managing on behalf of an owner, that means your management company contact information would be in that letter. And there are also 3 required statements that you have to add to this notice, which I will share with you here. 3 required statements. I did want to note a comment that came in. that is great nuance here. So if you are, say, HUD funded affordable housing where you're serving a low income audience, those do now require a 30-day notice to file. So the 14-day applies to market rate, but if you are in a affordable or subsidized situation, there is a 30-day notice required there. Thank you, my friends from Lloyd Management, for chiming in with that amendment. Yeah, somebody posted in here as well when it comes to delivering a notice. I've always been told to mail a copy and hand deliver. Sounds like a good process to me as well. You are sort of doing double to ensure that you have followed the process there. And that seems like a fair way to proceed moving forward if that's how you've done it. I see no problems with that. All right, let's look at these 3 required statements that are required in the 14-day notice. So here's statement number 1. Again, you will get a copy of these slides, so don't worry about having to necessarily write it down. But required statement number 1 is you have the right to seek legal help. If you can't afford a lawyer, free legal help may be available. Contact legal aid or visit this website to know your rights and find your local legal aid office. So somewhere on your 14-day notice, make sure that this statement is in there. Required statement number 2. To apply for financial help, contact your local county or tribal social service office. Apply online at minbenefits.mn.gov or call United Way, etc. So that's required statement number 2. And then required statement number 3. Your landlord can file an eviction case if you do not pay the total amount due or move out within 14 days from the date of this notice. Some local governments may have an eviction notice period longer than 14 days, but as our friends from Lloyd Management pointed out, if you are operating in the affordable space, 30-day notice may be required for you. So make sure you've got these 3 statements. So what do we have here? If we are doing a quick summary of what we're talking about here, is we've got what? Total amount due, specific accounting of the amount due, your contact information, and these 3 required statements delivered by first class mail or delivered personally. Some like to do both. Okay. Now let's move on to non-optional fees. This is something that you may notice. I'm just hearing a lot about this in the news lately across all different sectors of this term junk fees. I've heard it both at the federal level through the Biden administration. I've heard it both at the state level with Governor Walz and his administration, and going through the Minnesota state legislature as well. There's been some legislation that was passed that impacts the hospitality industry, the ticket industry. Thanks, Ticketmaster, for doing this to all of us, where the spirit of the law here is around price transparency. If you ever purchased a concert ticket and what the price that was listed was $50, and by the time you were done, $50 a ticket, and by the time you were done, it was like $84.63 per ticket. That, or if you ever tried to stay in an Airbnb and you're in that Airbnb and you're looking it up and it's like, oh, it's $100 a night. And then you see cleaning fees and other things. I'm not talking about the legitimacy of the fee here. I'm just talking about, I believe, what led to the passing of a lot of this. So non-optional fees now are required to be addressed in a specific way for Minnesota landlord tenant law. But let's open it up with a poll because I just want to know from the properties here, as well as anybody that serves renters here, what you have seen. Other than application fees and security deposits, what other required fees do you charge renters or have you seen charged if you're somebody that supports renters? So somebody sent in a comment that was kind of interesting here. They said, last eviction I did in May, an agency was at the Zoom courthouse meeting and offered help in paying rent right on the spot. Neighbor house, I think. So yeah, you might even have some agencies showing up to the courthouse or the Zoom courthouse meetings to provide that support on the spot if they may have some available funds. So that's helpful to know. Thanks for sharing that experience. Okay, we're seeing this like admin fees, processing applications, administrative fees. Have seen this before. Non-refundable pet deposits. Sure, I've seen pet rents before myself. Late fees, yes. So we know that late fees can be charged 8%. The maximum late fee is 8% of the amount of rent that is unpaid or the amount of uh, fees that were unpaid. Key replacement fee, animal cleanup fees. Yeah, these are all, some of those are things that put like if it happens versus what the spirit of this law is getting to is these whatever the renter is paying on a monthly basis that is required almost as a part of that monthly rent, that is more transparent. But it's nice to see this list of just the variety of fees that people are seeing. Using a credit card adds to a rental cost. Yeah, 'cause a credit card company charges their 2 to 3-ish%, and then that gets passed along to the renter. So legal and filing fees would be in a slightly different category than just late fees. So late fees is this is the amount of rent that's due, and the uh, rent is late, so the 8% late fee gets applied to that. But if a place has to go and now go through a legal filing process that comes with those fees, those get passed along as well. So I can see where that's, if somebody's just charging a pure late fee more than 8% of the amount due, that would be illegal. And that would be something to begin to pursue, contact legal aid about as well if that's happening. Okay, look at these association fees, holding fees, extra set of keys. Yeah, sure. Carpet cleaning when they move out. Yeah, in Minneapolis, we're now seeing shared utilities costs in apartment complexes. Yeah, there's been some interesting news articles just about some of the utility setups that properties have that feel a bit complex. Smart home fee. Oh, interesting. Liability insurance, pest fee, laundry, trash fee, admin fees, utility fees. Non-sufficient funds fee. Yep. Community fee like a damage deposit, but not refundable. Okay. Renter's insurance. I suppose I see what, yeah, they're paying for a service there, but additional costs for sure if we're pointing some of that out. All right, let's see what's coming in on some of the comments here. Somebody asked, what's the lowest amount you can give a letter of intent to file an eviction? So any amount owed. I mean, $1, right? Like any amount owed. So there is no bottom number that I have seen. If somebody owes you money and they're not paying it, you can send that letter. Fortunately, or hopefully, if that amount is low, they'd be able to see, oh gosh, and sometimes if an amount is low, I don't know, but you kind of want to give somebody the benefit of the doubt of like, maybe they just missed our message. Maybe they've been busy. Maybe they got a lot going on. So that's where this 14-day notice as well could be, where it's delivered in the mail or it's delivered personally, where it's like, okay, they're highly likely going to see this. That is like, oh, they can get that cleaned up, hopefully. All right. Lots of different types of fees. This is really interesting to see. Okay. Well, thank you so much for doing that little observation brainstorm. Okay. Let's keep rolling along here on this non-optional fees and what we are now required to do. So now required on the first page of the lease is the total monthly payment. And so that means the sum total of the rent and any required or what they call non-optional fees. So you got that lease, and usually in the lease, you see things like the address, the security deposit, and the rent amount. And then, of course, all the rules that people have to follow while they are living at the property. Well, now that first page of the lease, you have to make sure that it's including the total monthly payment that the renter has to pay, which is rent plus anything else. So it could be rent plus utilities and a pet fee, rent plus utilities, a pet fee, and any other regular monthly fee. You also want to list clearly in the lease all of the other optional fees or potential fees that exist. So required and optional, even if they are not in the monthly. So in terms of spirit of the law here, you are looking at people having transparency of what are all the things that they're going to have to pay. The way the law plays out here is here's your total monthly payment, and it's the sum total of the rent and all required or non-optional fees. But you also want to make sure that you have transparently and clearly and easy to see what are the other fees that people are required to pay or might have to pay along the way. So there are some requirements about how a property is advertised now as well. So in the advertisement, whether it's on Housing Link, Zillow, Craigslist, Apartments.com, or your favorite advertising platform of choice, you are required to put non-optional fees with the total amount for rent. So on Housing Link, how would you accommodate this? Because we just have a field for rent, security deposit, application fee. The way you'll have to do this on the Housing Link website is there is a listing headline section, and you'll have to use the listing headline. I know it's not an ideal use of the listing headline, but it's where we're at right now. You have to use the listing headline to put, here's your total amount for rent and non-optional fees on a monthly basis. And what's required in the advertisement, Housing Link accounts for this pretty easily, is whether or not utilities are included in the rent. So are utilities included in the rent or not? That now has to be in all advertisements in Minnesota, and non-optional fees with the total amount for rent. So going back here, what's required in the lease, that total monthly payment, sum total of rent and required non-optional fees, as well as non-optional fees with the total amount for rent, and whether or not utilities are included in the rent has to be in the advertisement. So somebody asked a question on late fees. If you have a subsidized tenant, would late fees be based on the tenant's portion or the full rent, or is it based on your lease? Well, in your lease, for a late fee, you are putting what late fee do you charge. You don't have to charge 8%. That's just the maximum that you are allowed to charge. And in a subsidized situation, typically the housing authority or whatever the subsidy is getting you your rent on time, particularly once like month 2 and on. Let's just say we're in the middle of the lease for simplicity's sake. Housing authority, they're going to get you paid, and you know that, I believe. So the late fee is for the unpaid rent amount. So if the housing authority covered their part, but the renter has not paid theirs, it's 8% of the renter portion in this case. So not of your full rent amount, only the amount that is unpaid. 8% maximum of the unpaid amount of rent. Somebody asked me, how do you feel about admin fees? Should renters pay them if they want to live somewhere? And is it required for the application, or do you believe it is a red flag? I don't really like giving my opinion quite in that way, but let me try to provide some perspective here. It appears that admin fees are pretty common in some way. And so what I would do is, if I was working in a renter in this case, and it's like the location of the property is great, you tour the property, it's in good condition, you have reason to believe that it's a reputable owner or management company, and everything else is a good fit, and they also charge this admin fee. In that case, I would not think that just a simple admin fee is a red flag. But let's say you're going to a property and the property's not in good condition. It's not a really good fit for the renter. And the owner or management company, for some reason or another, you don't think that they seem too reputable, then it might be. So you kind of have to look at how good of a fit is the place for a renter. But if somebody were to say, Josh, admin fees, huge red flag or not, I'd say generally it's not the top. It's not the thing that comes to the top of my list when it comes to a red flag, but I like to factor it into the full context of the story, if that makes sense. Okay, we got something coming from somebody who works from a housing authority. I want to take a look at this here, and some of these I may not have the answer for. And any questions that you've asked already that I haven't gotten to, we'll catch some of these at the end as well. I work for a housing authority, and we are seeing a large increase in non-optional fees for things not included in the rent since the landlord-tenant laws were updated on 1/1/2024. Interesting. So we see landlord-tenant law happens, and now we see a big increase in non-optional fees. Okay. It seems to be an unintended result of asking for them to be spelled out on the lease. Has there been any talk of limiting what can be charged as a non-optional fee? Good question. I have not heard any talk of that. And this is all so new that it'll be interesting to see how this gets sorted out over time. But I would love if you would send another message in from this person from the Housing Authority about what specific non-optional fees for things not included in the rent you are seeing. So we've got what you are observing as an unintended consequence of asking for them to be spelled out on the lease. Yeah, so before it was just kind of you had an amount, and now people are being a lot more detail oriented about spelling out these non optional fees to make sure that they follow a law that doesn't provide a ton of guidance on it. Okay, let's keep rolling. And again, I'll get to your questions, both the ones I think I can or cannot answer, all of them by the end. So don't worry. We'll maybe save a little section at the end. Temperature in the unit. This is another one that is new in 2024. So passed in 2023, there are new requirements around temperature in the unit. So let's do a poll question. What is the minimum temperature a landlord must keep a unit between October 1st and April 30th? So here's our, call it cold weather window. What do you think is now the minimum temperature a landlord must keep a unit between October 1st and April 30th? Somebody asked a question. Gosh, this gets complicated with utilities. And if anybody out there doing this has greater clarity on anything that I say, please let this be a group learning experience as well. Does the utility paid by the renter, if they are paying the utility company, only if they are paying the utility company, the building is charging a utility fee either prorated or a set amount? Okay, I don't fully understand the question, but let's look at a couple of different utility arrangements, even though they can be quite complicated. So you've got the one where you move into a property and the property says, here's the utility company information. The utilities get put in your name. You'll pay them directly to the utility company. And then the landlord is not connected to that. That's a pretty simple and straightforward, where you just pay the utilities directly to the utility company. You're not giving that money to the property. There are other cases where you are the utilities might be in the landlord's name, but you are paying that money to the landlord. But it might be the landlord saying, all right, I've got the rent amount plus utilities here, so it's not included in the rent. And then you might have others where the landlord says, all right, I know that for this unit, the utilities are going to be about this, so they'll charge you one amount. This is your amount for rent plus utilities. And then there are, of course, other places where you've got somebody paying utilities, but they're just paying like a set fee, or they might be paying based on usage. But it kind of depends on how the property collects it. So when it comes to how they are advertised, the way the law speaks to it is that the landlord just needs to indicate whether or not utilities are included in the rent or not in the ad, because what the law is, the spirit of the law here is they're trying to help. I believe what they're trying to do is they're trying to help the renter to see, here's what your monthly cost is going to be to live here. And so if it's rent plus utilities that's based on usage, well, that should be clear in the ad. Or if it's rent is included in the utilities, let's be clear about that in the ad. Okay, yes, the majority of you have gotten this one right. Our minimum temperature a landlord must keep a unit between October 1st and April 30th is 68 degrees. So if the property is controlling the temperature of the place, that is the minimum temperature required now. So there's a cold weather rule. This is I wish they didn't call this the cold weather rule, because there already is a cold weather rule that utility companies are required to follow related to shutoffs. Now we have a cold weather rule related to rental properties. And that's where a utility must remain connected for a customer whose household income is at or below 50% of the state median income if the customer enters into and makes reasonably timely payments under a mutually acceptable payment agreement. So, if you're a property that's serving those who have incomes at or below 50% of the state median income, Where can we get the state? I mean, there's a lot of different median incomes out there, many of them based on county. This is based on a state median income. So that's going to be quite a bit lower than I would assume the Hennepin County median income, for example. But anyway, just know that if you're serving folks who, so this means if you're a property that's accepting housing choice vouchers or you operate physical project-based Section 8 public housing types of units, this one would have an impact on that. And keep in mind the cold weather rule here. I'm just looking at questions coming in here. Somebody asked, and I don't know the answer to this, so somebody, if you do definitively know the answer to this, please use the form. Can a landlord or property management ask for a copy of your county benefits card, your SNAP card? Are you allowed to do that? Does anybody know the answer to that? I don't know. So generally what takes place with a property is, think about your, so I don't know the specific answer to that question. Maybe somebody else does, but let's talk about what we're actually trying to do here for a moment. So you've got a rental property and you have your screening criteria. Here's what we require for income, sometimes credit score or credit history or credit background, as well as criminal background. So income, criminal credit, rental history. Those are our big categories of screening criteria. And for income, you're looking at what do they have for income to pay the rent. So that could be earned income, that could be disability income, that could be any money that they could use to pay the rent. So in fair housing, and in our local fair housing laws, we have a protected class of receipt of public assistance. And so what that means in practice is that you have to allow someone to use as income anything they could use as income to pay the rent. So you couldn't deny them based on their source of income they use to pay the rent. So I'm not sure why one would ask for a SNAP card, which is about, if my understanding of SNAP is correct, it's just about paying for food. Why one would need a copy of that. But provide more context, because obviously there are details I don't know. And so I'm just thinking through this off the top of my head, but why would you ask for a copy of that benefits card? I understand if somebody's paying less for food, it might make it easier for them to pay for the rent. So I can understand that. And if you're doing it in the spirit of showing flexibility, so you can see like where you're looking at, all right, the whole picture. They don't make 3 times the rent in income, but I see that they have all this additional support and I just need verification of these supports for me to make this exception. I could see that. So lots of good. All right. So somebody says related to that, if you are HUD subsidized, it is required to receive subsidy. Okay. Somebody says, no, they are not. Yes, to verify the asset. All right. In affordable housing, we must take a copy of the card, block out all the numbers, but the last 4 digits for compliance asset verification. Thank you very much. So if you are in affordable housing, we must take a copy of the card, block out all numbers, but the last 4 digits of compliance asset verification. Then somebody says, for the recertification purposes, the cash portion, yes. Okay. What a fun community learning experience. Even I get to learn so many new things during these. Asking for benefit cards amounts is required for some sources of funding, Minnesota multifamily and tax credit, for example. Very nicely answered. Thank you. Some more coming in. Somebody says only if they get cash on the SNAP card. So, yeah, this is all coming together now. In affordable, you can request a receipt to show the balance on. Okay, I see. Yeah, okay. I think we got our answer there. So in affordable housing. So here we go. Somebody is saying something else. As for the SNAP, if you have someone who isn't making 3 times the rent and income, some places will ask for SNAP cards to verify the assets on the card. Some places will use the balance that a person gets from SNAP to bring the income up. Yeah, so it's being used to help them meet that requirement. So we got the SNAP card, cash balance, and being able to use some of that portion to get them income up to see if they can be qualified for the unit. Thank you. And then somebody says, yeah, the SNAP card is considered an asset. Okay, great. I think we have our answer. You all are spectacular. Okay, let's keep on rolling. But remember that cold weather rule, 68 degrees. And if somebody earns 50% or less of the state median income and they enter into and make reasonably timely payments under a mutually acceptable payment agreement, those utilities have to remain connected. But also remember there's a cold weather rule for utility companies that if somebody is uh, behind on the utilities during the cold weather months and that renter, let's say the renter is working directly with the utility company in this instance, that renter can set up a payment plan with the utility company and they have to remain connected as well. That's sort of a long story short, but okay, now let's get into the landlord entering the unit. So we got newly defined requirements on what type of notice is required before a landlord, property owner, manager can enter a renter's unit. So let's do a poll question on this. How much notice is now required before an owner manager enters a unit? Is it just reasonable notice, 12 hours or 24 hours? Getting our answers in now. This is great. So before January 1st, 2024, the law just required reasonable notice, which is pretty gray. However, as somebody who has worked in this industry for about 18 years, reasonable notice was generally interpreted as 24 hours, but there was just some wiggle room in there. That maybe if something was going on, the landlord could say, hey, landlord could say at 9 a.m. that day, hey, I've got a vendor who they can only, get into, do this repair. Just want to give you a heads up that they'll be in later today at like 5 p.m. And that back then would have felt squarely within a gray area of the law. Reasonable notice is generally considered 24 hours. In that case, they got 9, and it's sort of like a little bit of a roll of the dice. Well, that wiggle room has gone away. So now it is 24 hours of notice that is required. Okay? 24 hours of notice before entering the unit. We will talk about exceptions in a moment, but the wiggle room, the gray area of the prior reasonable notice era is gone. Okay, well, let's keep going here. This is another poll question. During which hours of the day can a landlord enter the unit for a non-emergency? Okay, so with this 24-hour rule, what are the hours? Because that will impact your notice. Is it they can enter in any time? Is it 8 a.m. to 8 p.m.? Is it 9 a.m. to 9 p.m.? They're the property owner after all. So what options do they have here? Okay, yes, the majority of you are saying 8 a.m. to 8 p.m. Some of you said 9 a.m. to 9 p.m. And a few of you are saying, yeah, still any time is fine. Our correct answer here is 8 a.m. to 8 p.m. So those are the hours that the landlord can enter a unit for a non-emergency. So now we require 24-hour notice before you're going to come into the unit if you're a property owner or manager, and you got to honor these 8 a.m. to 8 p.m. hours. So greater emphasis on renter privacy, greater emphasis on renter awareness of when you might step in or enter the unit. So what are the exceptions where no notice is required? Basically emergencies, tenant safety and security, as well as a true maintenance emergency. What would not be considered a maintenance emergency would be oh, I have an inspection and I forgot that it was coming and I don't want to have to reschedule this another week out. That does not count as a maintenance emergency, as you well know, right? Maintenance emergencies, leaks, holes in the walls, electrical issues, true maintenance emergencies. In these, a property can still enter in at any time in the interest of tenant safety and security, or a maintenance emergency issue, or sometimes law enforcement gets involved as well. Now, there is one other caveat to this particular law, though, is that the landlord and the renter can agree to bypass this. Meaning what? So to bypass the 24-hour notice. So the landlord, by law, has to provide 24 hours. But let's say, gosh, I've got this vendor, I'm trying to get this repair in, and they rescheduled on me, and they only have this window. Well, a landlord in this case could say, hey, renter, got an issue with a vendor. They rescheduled on me, and now they are able to come later today instead of tomorrow. And if they don't come later today, then they're going to be a week out. Would it be okay with you if we came in and did it at that time? If the renter says, yes, that's fine, then you can go ahead and do it. But if the renter says, no, I'm not comfortable with that, then you're going to need to give them 24 hours. So it does allow for both parties to have a conversation and say, yes, that's fine. But the renter is allowed to enforce their rights in a non-emergency situation and say, no, you have to do a 24-hour notice. So I assume that's clear, but if it is not, let me know if you have any questions on that. So 24 hours, 8 a.m. to 8 p.m. Emergencies are exempt, but you can also have a conversation with the renter and see if they're willing to show flexibility. If they are, go ahead and enter the unit. If they are not, then you got to follow the 24 hours and the time of day requirements. So no surprise drop-bys for anybody anymore. Not that surprise drop-bys were ever legal, but I have actually my own story with this that I like to share, because also, as these new laws come available, not every new property owner manager is at this training, are they? And not everybody's going to know the law, and so we want to first have our hats of patience on and being educators and understanding that we want to have a successful tenancy. So me and my now wife, a number of years ago, we were living at this duplex in Northeast Minneapolis. About a week after we moved in, it was 8:03 a.m. And at the time, we were still in bed. And then we heard this knock on the door, just like basically in our pajamas, and let's leave it at that. And and it's like, oh my gosh, who's here? And it's like, Tim's here. It's like, what is Tim doing here? And sure enough, Tim had a city inspection that day that was, probably required as a part of the rental license. And I looked at my email, and he had sent an email 6 minutes earlier. Hey, need to stop by. Like, under no world would that be considered reasonable notice. But I've worked in the industry for a long time, and I was like, okay, this is the beginning of the lease. I want to have a really good relationship with this property owner. I don't want to assume that it's going to be some sort of bad thing, so I'm not going to say anything about it. Well, about 6 days later, the same exact thing happened again for a different type of maintenance non-emergency. At this point, it's getting a little bit irritated because it's also a non-even reasonable notice under the old rules. But I thought, okay, we're still early in the lease. I don't want a contentious relationship. I'm going to do a 3-strike rule. If this happens again, then I'm going to start talking about reasonable notice in the law. But if it doesn't happen again, we're going to be good. And what happened? Never happened again. So if you are an advocate or a case manager, and of course, this was not a creepy stop by. It was just inconvenience and a bit violating, but not dangerous, let's say. So let's put things in somebody's being disorganized and unprofessional versus somebody is being creepy. If somebody's being creepy, we're going to enforce that, right away, right? But if somebody is being disorganized, well, we might show a little bit of patience for the sake of it. You get to make the judgment call. I'm just saying when we're dealing with the law and we're dealing with our rights, we sometimes have to figure out how do we best handle them interpersonally, especially when the rules are new. But you can also be a real stickler for the rules if you like. Okay, let's see. A couple questions or comments that have come in here. What should a staff person do if the tenant requests a staff person to fix something right away, even if it is not an emergency? Well, it's it's kind of a customer service thing that's going on here, as well as your existing processes, I would say. So if you're living in a place and something's broken, you do want it fixed right away. And that could be like, hey, could you guys get this fixed right away? And if you can, great, fix it right away. But if you have a sort of first come, first serve or priority based maintenance backlog, you just want to be transparent about that as well. You say, oh, here's where you could submit the maintenance request, or here, I'll write down your maintenance request just so you know. This one is third in line on these. So here's an estimate of when we believe we'll be able to get to that. And so much of professional property management comes down to a lot of times people just need transparency of what can be done and when. And we're in a society right now where at the click of a button, we get anything we want. And then that sort of mentality comes into rental housing where they want the same convenience, ease of interaction and getting things fixed as they have in every other element of their lives. And to the extent that you can accommodate that, great. To the extent that you can't, provide transparency on, hey, here's what our process is, here's what the timeline looks like, and here's when we'll be able to get to it. What makes people frustrated is when they don't hear back, or when they're just given like, oh yeah, we'll get to that, and they're not given a timeline, they're not given any transparency. That's when people start to complain a lot. So transparency and setting expectations and just letting them know, I'd love to be able to get to that right away, but vendors in this area are really short. So we're looking at 2 weeks right now, but I'm going to try to get somebody in there as fast as possible. Usually this takes 2 weeks. Let me contact them and I'll give you an updated timeline shortly. And if you're dealing with a reasonable individual, most will be fine with something like that. That's my thoughts on that one. But if anybody else has things that you think are a better way to handle it, share your recommendations. Okay. Notice requirements for lease renewals and non-renewals. So this one gets into sort of existing landlord-tenant law, that you've got this lease term and we've got the renewal, non-renewal, or possibly a rent increase coming in. So you got to follow what is in your lease here. And the parental property cannot require the tenant to give more notice than they do. So if you require that the renter is going to, if you require them to give you 60-day notice of renewal or non-renewal, you need to give them 60-day notice of renewal and rent increase or not, and non-renewal. So it has to be an equal amount. Or if you're just going to give them a full rental period plus 1 day, then all you can require from them is a full rental period plus 1 day. So it's, whatever it is spelled out in the lease, and it's got to be equal. And if nothing is specified in the lease, then the state law reverts to 1 rental period plus a day. New in 2024, no forced early renewal. I should do a poll question on this because I was just surprised that this like even happens. But landlords cannot require tenants to renew their lease more than 6 months before it ends, and that's for any lease of 10 plus months. So I guess there are some places that require a person with more than 6 months left on their lease to let them know if they plan on renewing or not. That is no longer allowed. So at least 6 months of the lease has to pass in order. That's the earliest you can require someone to let you know that they plan to renew or not. It's just, I've seen it be so common of 30 to 60 days that to see like more than 6 months was a bit of an eye opener for me, but I guess I don't need to let you into my inner world. But there are all sorts of, the wonderful thing about rental housing, the wonderful thing about life is there are so many like dynamic situations and different needs that people have that really cause these things to surface. Like maybe people have got some big projects going on and they want to know. And so that's where we like always want to assume good intent on something, but then the law can still come in and reset things to be a little bit more reasonable. Today's training is focused. I am going to get through some of these handful of questions that have come in related to HUD's rules and some of that. Today's training is really focused on Minnesota landlord tenant law. It is not with the intersection of HUD, but many of you have given me an idea for a good training where we'll bring somebody in who understands the intersection of, well, you got Minnesota landlord tenant law, and then you have these HUD rules as well. Seems like it might be helpful for some if we did a training on HUD requirements for affordable housing, and we could put them in the context of that. Some of these I just don't know. Oh, let's see here. Usually I've seen this in college housing. This person from Lloyd Management, just my favorite today. So requiring a early renewal in the case of college housing, yeah, that's like one of those dynamic situations where you could see where a property would want to know so that they can, because they have these like tight windows of rental. Makes total sense, I guess. But they have to wait now at least ensure there's at least 6 months left. Uh, no more than 6 months before it ends for a 10+ month lease. All right. Yeah, somebody says yes. It'd be very helpful for the HUD compliance training. That sounds like a thriller, doesn't it? No, it sounds like a great idea. Okay. Okay. Application fees. Poll question: is a rental property required to provide the applicant a receipt for the screening fee? Yes or no? So this is a poll question you can answer there in Mentimeter. Is the rental property required to provide the applicant a receipt for the screening fee? See, as a people pleaser, I like to be able to answer all of your questions. And then when some of these come up that have these nuances related to, well, there's Minnesota landlord tenant law, but then there's also HUD. Somebody also asked, like, does that include HUD, that renewal? This is just Minnesota landlord tenant law. I can't tell you on the HUD side of things there. But the while you're answering this poll question, there is a question that came in. 24 hours. We're talking about notice before entering the unit. 24 hours or just prior day notice? 24 hours. So prior day notice, because prior day notice was kind of like the old school flexibility of reasonable notice, like 24 hours / the day before is fine. The law says 24 hours. So if you text the renter at 1 p.m. that we're coming tomorrow at 10 a.m., that's not okay. It would have to be tomorrow at 1 p.m. or later, correct? Yes, that is correct. Your understanding is correct. It is 24 hours. You know, I had a slide that disappeared related to the penalty for not following the correct notice. And so I'm just going to bring this up in landlord tenant law, that if somebody enters a unit without providing the 24-hour notice, what remedies does the renter have? I will find it in a minute. I got more poll questions, so I can look it up in a little bit later. But yeah, the correct answer here to this question related to application is yes, a receipt is required. Some of you might have answered that no, because you're like, we haven't received a receipt. Read the fine print on the application. Usually what'll happen is the property will have you fill out the application and you pay your application fee with the application. And on that application, commonly there is language that this is your receipt as well. So yes, a receipt is required, and it is often the application itself. So look for the fine print. But if there is no fine print there, you should be getting a receipt of the application fee. Another poll question. If a rental property charges an application fee, are they required to process applications on a first come, first served basis? Okay. So I said I would look up what is the penalty if a landlord doesn't follow the 24-hour notice requirement? Here's your penalty. It could include a rent reduction up to full rescission of the lease. So meaning that if at that point the renter says, I want to break my lease, they could take the landlord to court to break the lease as a result. So this is a big one, right? So If a landlord does not provide the 24-hour notice, a renter could break the lease, get their damage deposit back, less any amount retained for damage beyond ordinary wear and tear. So it's like they could break the lease and the security deposit doesn't get to apply to the rent moving forward. It would only apply to any damage to the unit beyond ordinary wear and tear or any other unpaid fees, and a $500 civil penalty for each violation and reasonable attorney fees. So don't play around with this one if you are a property on this 24-hour thing and reasonable notice, because the renter could break the lease, you're going to give their security deposit back, and you could be taken to court for $500 plus attorney's fees. Doesn't sound fun to me. Yes. Okay. If a rental property charges an application fee, are they required to process applications on a first come, first served basis? Yes, that is correct. If they charge an application fee, they got to take this application, approve it or deny it, and then move on to the next one. And anybody that has given them a check or money for an application fee that didn't get it processed, those obviously they do not get processed. All right. One more. Is a rental property required to share their screening criteria in writing if they charge an application fee? Somebody asked, our application is through a verification company. Is their process in response to the resident adequate, or do we need to provide the receipt? So I'm guessing here what's happening is you're sending them to a website. They go online, they apply, they pay the fee, and then that company issues a receipt, kind of like you're paying online. You get an emailed receipt. That I'm sure is fine. As long as they're getting a receipt for the application fee money that they paid, you are good to go. So somebody asked, I may have missed this in the beginning. Does all of this you are sharing today apply to landlords who only rent one single family home and have no other properties they rent? Yes. This is Minnesota landlord tenant law that applies to all residential, well, applies to residential rental properties like yours. So what you don't have here is, like, for example, in fair housing, there are some exceptions based on the properties that you have, where landlord tenant law just applies to. This is what these are the rules and laws that govern your interactions when you're renting out a property, even if it's just your one little single family home or big single family home uh, as well. So yes, it applies to you as well. Good question. Okay, yes, rental properties are required to share their screening criteria in writing if they charge an application fee. So you got the application, and then usually on the back of the application or as an amendment to it, they should have there, this is what we require for income, credit, criminal background, rental history, and anything else. If you meet this, you get approved and you move forward. If you don't meet this, you will be denied. You will be denied. Okay. Now, one thing I'd like to say, this is particularly for larger management companies who have leasing agents or frontline staff. I'd strongly encourage you, if you ever have renters with criminal credit or rental history barriers, come to your place and they talk about, yeah, I've got this thing in my background. So often what happens here is the leasing agents will say something like, okay, thanks for telling us. Well, it'll probably be okay. Just, you complete this application and we'll let you know. And then what happens is these people pay their $50 application fee, their application gets denied, and then we know they don't get that money back. I would really like to start to see, and maybe that'll be one of our next trainings too, is that frontline staff are super sensitive to anybody who shares a barrier up front, that they'd say, hey, before you apply, make sure to check our screening criteria. Let me know if you have any questions, because if you don't meet all of these, 100% of these, you would get denied. And if you get denied, you're not going to get your application fee money back. Okay, so that would be a great service provided to that individual, because money is tight and it can be a really big challenge. So please have staff provide a bit of education of what it means to complete that application and what criteria has to be met, because not having them do that, I will share an opinion that I think that's going a little bit too far in terms of you're trying to not generate any fair housing complaints or discourage anybody from applying. We're not trying to discourage anybody from applying, but what we have is somebody who's saying, I have this criminal background thing, or I have this other thing in my background. Well, in that case, you could say, oh, well, here, take a look at the criminal background section of our screening criteria. If you don't meet that, then that would mean you're not eligible to live here. And and that way you can save everybody time, money, hassle along the way. Okay, well, wait a second. Did I answer this? Yes, the correct answer here is yes. Rental property is required to share their screening criteria in writing. Oftentimes it is on the back. Final question, I think final poll question about application fees here. When does the rental property have to refund the application fee? Is it never if the renter does not meet the screening criteria? If the renter is denied for a reason not listed in the screening criteria? We'll see if any other questions come in. Can we require only online applications to avoid paper applications? Okay, good question. Can we require online only? Yes, but you might receive reasonable accommodation requests for a paper application, so you'll want to be prepared for that. So reasonable accommodation meaning if somebody has a disability and maybe an online application is not working for them for one reason or another, for the purpose of reasonable accommodation, you may want to have some paper applications, but so you could say like applications only happen online, but somebody may say, hey, I have such and such disability that prevents me from being able to go online or use an online application, so I need a paper application. So you just want to be prepared for that. So the short answer is yes. The long answer is be prepared possibly for a reasonable accommodation request. Okay, here are the answers streaming in. When does the rental property have to refund the application fee? Some of you say never. Some says if the renter does not meet the screening criteria, and the majority of you say if the renter is denied for a reason not listed in the screening criteria. And that, my friends, is the correct answer. So the application fee has to be refunded if the renter is denied for a reason not listed in the screening criteria. So what does this mean? You got the screening criteria. And let's say that the renter meets all of it, but then the landlord says, I'm not going to rent to you because of this other thing. And let's say this other thing, it's not violating fair housing, but they change their screening criteria. For example, let's say they change their screening criteria. So they applied under this screening criteria, but now they changed it and it wasn't listed in there. They can deny that renter. They better be careful that they're not violating fair housing, but they can. But if they do, they have to refund the application fee because the renter was denied for something that wasn't listed in the screening criteria. Okay. So application fees are not refunded if the renter does not meet the screening criteria. It is the renter's responsibility to review the screening criteria, make sure they meet it and only apply then, or review the screening criteria, see if the place is willing to make an exceptions as well. That's a different story. But yes, if a renter is denied for a reason not listed in the screening criteria. Question that came in. What about applications that come through Zillow or apartments.com where the website charges them the application fee? Do landlords need to refund when we don't collect the fee? Well, if you deny them for a reason not listed in the screening criteria, then you're going to need to find a way for Zillow or apartments.com to get them that refund. But if they paid through Zillow or apartments.com and the person didn't meet the screening criteria, well, then that's not refunded anyway. So it's a pretty small set of circumstances where an application fee gets refunded. But if they fell within that, then you're going to have to get it refunded. But they do have to get a receipt, but I assume they're getting a confirmation email receipt, or it's in the portal where they can access it for companies like that. But otherwise, you would have to get it refunded if it falls under this particular use case. So somebody said, on that suggestion regarding reviewing the screening criteria prior to applying, applicants who are denied can appeal. How do you share this? So that to me enters in so much confusion. So in addition to doing what I'm doing here, I also work with Housing Links Beyond Backgrounds program. I have a lot of different communications back and forth with renters who have criminal credit and rental history barriers. And to me, this is like, well, what determines the appeal? Like that should be clear up front as well. So here's how you can appeal. Here's what the appeal means. Here's what appeal will be successful. That should basically be all known up front. Because otherwise you're saying, all right, you don't meet the screening criteria, apply now, you can appeal, but can they appeal their violent felony from 3 years ago? Does that work? Is it just for credit? Is it just for an eviction that was 2.9 years ago? Like, what is considered in the appeal, so that that renter can make an informed decision of, this is worth it to risk this $55 application fee or not. So to me, so what I would suggest is, if somebody comes up to you, so maybe your process, let's say your normal process would be something like, okay, if you want to apply, first take a look at our screening criteria. This is what determines if somebody is eligible to live here or not. If you meet all the screening criteria, you'll get approved. If you don't meet all of this, 100% of it, you would get denied, and the application fee is non-refundable. Let's say that's your normal process or something like it. But now let's say you have somebody who comes up to you and they say, hey, I'm interested in living here, but I kind of have this thing in my background, and it's a criminal thing. So I'm just kind of wondering how that works. And hopefully they provide more detail than that, but let's say they're providing that little amount of detail. You can say, okay, well, here, take a look at our screening criteria. Here is what somebody has to meet in order to live here. If you don't meet 100% of this, you would get denied. But here are the exceptions, or here's our conditional approval screening criteria. Or if you're not approved, here's what the appeal process looks like. Here's the appeals that get approved. Here are the appeals that don't. And so that they have enough, because we have a lot of folks out there who they're either experiencing homelessness or on the verge of homelessness, some in a really desperate situation, some that are living in the car with their kids, and they will spend $55 out of a shred of hope and then lose that money. And so that's where I used to be a leasing agent, so I know how this works really well. Your job is to represent the property. It looks good when you get applications in and you're showing that you're a good salesperson, but this can have a really outsized impact on people with low incomes or barriers. And so those are cases where we want to take off the sales hat, especially if somebody's revealing up front that they're interested, but they got some issues, and put on more of like the guidance hat of, all right, here's how this works. Before you apply, and you put down that money, you want to make sure that you're going to meet this and that the appeal process would be worth it. All right, let's keep on rolling here, and I can always spend a little extra time at the end for questions if we need to. We're almost done with this anyway. Okay, another poll question. Within how many days, okay, that was written poorly, with how many days does the rental property need to notify the renter that the application was denied? So if the application was denied, within how many days does the rental property need to notify the renter? Somebody asks, is a text message to the applicant that we received $50 for the rental application fee acceptable as a receipt? Probably. I'd prefer something that feels a little more permanent, like an email. An email that says like receipt for application fee. But yes, you could. I mean, text messages are pretty common for receipts now. And it's likely that you're not going to have a refund thing. So you're not going to deny somebody. So yeah, it's fine. It's fine. It's fine. It's documentation. It's acceptable. Oh, for clarification, what if the application comes back conditional and the resident decides not to take the unit? Do we refund the app fee? No. So conditional approval means you didn't meet our initial screening criteria, but we will rent to you with a double deposit, cosigner, beyond backgrounds, financial assurance, whatever it would be. But if they say, no, I don't want to do any of that, then that is an application that is denied and it is not refunded. Somebody asked, what if the screening criteria is income-based, but the employment history is short enough that it isn't possible to prove consistent income? Well, that's something you'll need to clarify in your own screening criteria. That's where I've seen some say we need to see 1 consecutive year of employment history, or 2 consecutive years of employment history, or 3 consecutive years of employment history. You get to choose based on your property and operations what is the best fit for that. So I have seen some who they just care that you have the income now and they're not concerned about consistent employment history. I've seen others that say we need 3 consecutive years of income earned at this level. So based on your property, based on your your location, based on, your spirit of flexibility. You get to choose. Somebody says that if an applicant gets denied by you through apartments.com, they don't need to pay for another application fee on apartments.com for a totally different place. So looks like apartments.com has a setup where, all right, you're going to pay sort of this app fee once, and for other places on our platform, I imagine there's a clock that ticks on it. It's good for 30 days, maybe 60 days. You could probably tell me, but that's cool. It's good to know. Thank you. But not every place is on apartments.com. Not every property does their applications through apartments.com. So good for those use cases for sure. Devil's always in the details. Sometimes renters pay application fees to apply to multiple properties through those websites. Just by my advertising on those websites, I receive unsolicited applications. I still have to refund app fees to unsolicited applications. Sounds like those websites, this sounds related to the apartments.com, that they're saying pay once, apply to many different places. So that falls in a different category of things. I don't know enough about how that money is distributed. Okay. So there's a devil in the details there that I don't quite know. Okay, do you have to offer them a double deposit or cosigner if they don't qualify on their own? You are not required to provide conditional options. So that's what's called conditional approval, where there are some places who say, all right, if you don't meet our income requirements, but let's say we require 3 times the rent and income, but you're 2.75, we would rent to you if you have a cosigner or a double deposit. That's called conditional approval. You can do it, but you're not required to do it. You can just have your screening criteria and say, this is it. But others, you often see this with larger management companies, will have that conditional approval, but you do have some flexibility there. Yeah, so it looks like apartments.com and Zillow do transfer of application fees. So there's so they're paying like $50 to maybe 50 to 75 or whatever to Zillow and apartments.com. And then they're saying for other properties on our platform, you can apply. People are getting some unsolicited applications. So in those, it seems to me like you do not need to refund anything because they have a different model. And yeah, so I would say in that case, it's not really coming through you. It's going through them. Yeah. All right. A couple of other application fee requirements in our more traditional zone for a moment. You do have to provide the contact info of the screening company. You got to let the renter know the criteria they failed to meet if they were denied. And the application has to be used to perform a reference or background check. So it is a pass-through fee to a company performing a background check. You can't just charge an app fee to process paperwork. The app fee has to be for the purpose of verifying information that sort of what is often a pass-through fee. So just for everybody tuning in, generally what happens here is you got a property. They work with a screening company, and the screening company says, we charge you $50 to do this. So property charges you $50. They give that $50 to the screening company, and that's how it works. Or now we're seeing in more modern cases, you're going to go onto that screening company's website and you are going to apply there. That's where the properties need to have. That's why you don't generally see properties deny people for a reason not listed in their screening criteria as well, because it just creates a lot of complexity and risk. Okay, I mentioned Beyond Backgrounds and Beyond Backgrounds financial assurance throughout this training just a couple of times, just in case you are not aware. At Housing Link, we have this program called Beyond Backgrounds that's designed to support properties who are renting to people that may not meet their initial screening criteria. So here's how it works. With Beyond Backgrounds, the renter, they pay $300, kind of like renter's insurance, but the attorney said that Housing Link could not use the word insurance, so they call it Beyond Backgrounds Financial Assurance with an A. No cost to the property, but the renter pays $300, and then the property gets accessed up to $2,000 above what their security deposit covers at the end of the lease if there's any damage to the unit, unpaid rent, legal fees, or any other issues. And so let's say you have conditional approval. One of you mentioned this. Beyond Background's financial assurance could be a good option to add to your conditional approval because it gives you extra financial coverage, but at a lower cost to the renter. So it makes it easier for the renter to pay their next month's rent and their other bills while also giving you that same financial security. I'll give you an example of a conversation I had with a property yesterday. So the property said, Josh, we have one of these renters where our rent is $1,500 a month. We would rent to them, but we would require a double deposit in this case. So the renter would need to come up with $3,000. And that's like, actually, if it would make a difference, you might actually want to consider Beyond Background's financial assurance, because in this case, the renter they'd pay an additional $300, and you, the property, would get access to another $2,000. So it's actually more financial coverage for the renter, and they pay $1,200 less out of their pocket. That's huge in terms of a greater likelihood of financial sustainability through the course of that lease. So if you do want to refer a renter to purchase the Beyond Background's financial assurance, I'm just going to add this to, so we're going to go beyondbackground.card.co like this. Here we go. There's your link that you can refer a renter to purchase the Beyond Background's financial assurance. And when they buy it, you'll get an email automatically that indicates this renter applicant interested in your property purchased Beyond Background's financial assurance. Then you can move forward with your own application process, no inspections or anything like that. And then at the end of the lease, if there's any damage to the unit or unpaid rent, first you apply your security deposit. And if there's still leftover expenses, you just fill out an online claim form to purchase it. One quick testimonial on this, and then we're going to wrap up, and I'll take a look at some of these questions I didn't answer too. But from William Cullen of First Select Property Management, he said, Beyond Backgrounds has been a game changer for us. We've expanded our rental criteria and accept families with lower credit and income than our standards previously allowed. We believe the financial assurance from Beyond Backgrounds eliminates the financial risk. The program's super easy, always approved and affordable to the applicant. The best part, we have not made a single claim a win-win. So that's just a heads up on Beyond Backgrounds. Now, as we close, let's go into security deposits. Now that the commercial's over. Okay, go ahead and answer this poll question. How much does your property currently charge for a security deposit? This is just an open-ended question. So somebody asked, I've noticed Zillow allows multiple people to apply to the same unit at the same time. Is this legal? Well, the first come, first served rule would still apply. So I assume one of those comes in like a second before another. So what that would mean is you'd have to approve or deny the first application and then move on to the second one. So the same time would be like, you still have to process them in the order in which they came in and approve or deny them in the order in which Zillow sends them to you. So I don't see anything illegal about it, but you still have to follow the first come, first served approval based on when the application gets sent to you. Is there a reason one would be denied for Beyond Backgrounds? No, there are no eligibility criteria for Beyond Backgrounds. We do not vet the renters up front. We do not approve or deny them. These are things where the property can just say, we want you to purchase this financial assurance in order to rent here, and then they can buy it. And there are no eligibility requirements on that side. They don't come recommend, like if a renter mentions Beyond Backgrounds to you, they are not recommended by Beyond Backgrounds either. We just operate the financial assurance. And if you want a renter to purchase it in order to live there, they can. No requirements to get the coverage. They go online and buy it. Okay. Oh, yeah, you said you missed the days to notify the renter the application is denied. You missed it because I did not answer it. So let's go back here. The correct answer on this one is 14 days. So it's not actually 7 days, it's 14. So within Minnesota landlord tenant laws, if you deny the application within 14 days, you need to notify a renter that the application was denied. Okay, 14 days. Thank you for holding me accountable. All right. We're almost done here, folks. And then I do want to get back to some of those questions. Nobody needs to stay around for them. Okay, your property, you currently charge 1 month's rent, $500 at one, and 1 month's rent at the other. Yeah, okay. 35, is that a security deposit or is that an app fee? Never, doesn't matter. 500 for those who meet initial screening criteria, 750 for those with the conditional. We charge a set community fee at our assisted living apartments, usually 1,500. Okay, fair enough. Okay, thank you. If there are issues, how quickly must a property return the security deposit? 2 weeks, 3 weeks, 4 weeks? What do you think? Who, if any, is auditing these checks and balances? Really nobody. It is up to the renter to understand their rights. That's why we do trainings like this, so you understand the rights. Larger management companies do a pretty darn good job, in my experience, in general, of making sure that they are compliant with the law and giving their staff a lot of access to training. But it is about understanding your rights and knowing them, because there's not a lot of enforcement going on beyond reporting what you've experienced. I've had 2 participants sign up for Beyond Backgrounds, haven't been able to get in touch with anybody. So the way it works, we got this sort of front end sign up on the website, and then they do have the option to chat through an online chat. It starts with a bot that answers their questions. If they still have questions, they can then get connected to a human. And so that is how we handle the support to renters on the front end. Some folks have been given a phone number at times where we'll do some texting as well, but I'd encourage them to click on the chat with a housing coach, walk through the upfront, call it AI bot that provides a lot of that information. And if they still have additional questions, to ask it there. And if they asked before and didn't get an answer, try again, and we'll make sure we get in touch with them. Do I still screen the Beyond Backgrounds applicants with my screening criteria? Yes, your process remains entirely the same. But what you'd be doing in this case is saying, okay, I see you don't meet our initial screening criteria, but you are the kind of individual where I will rent to you if you purchase the Beyond Backgrounds financial assurance. That's when they should buy it. That if they buy it, it means you're willing to rent to them. But all your processes remain the same. All right, 3 weeks. If there are no issues, how quickly must a security deposit? How quickly must a property return the security deposit within 3 weeks? I'm going to answer this because we're essentially out of time, but I'm essentially done as well. 1% interest is applied to the security deposit now, so it should be returned with 1% interest, not compounded. So 1% interest from the original amount. And reasons a property can withhold the security deposit: unpaid rent or other fees, or damage to the unit beyond ordinary wear and tear. That's still very much a gray area, but that is how it works. And a property should make sure to provide a letter summarizing the costs. So here's why we're withholding your deposit. Damaged carpet, here's what it costs us to clean it. Damaged door, here's what it costs us to fix it. Damage this, here's what it costs. Unpaid rent, here's what that costs. And finally, this is actually the last thing. A property needs to notify the renter in writing of their right to be present for both the move-in and move-out inspections. So when the renter moves in, you want to do a walkthrough to document the condition of the unit. The property needs to notify the renter in writing that they have a right to be present at that inspection. And then when they move out of the property as well, they can notify them of their right to be present at the move-out inspection. So, new in 2024, rental properties can't require pet declawing and devocalization. So if you're requiring, we'll rent to you, but you have to have that cat declawed, you can't do that anymore. And my final renter requirements: 3-day notice before vacating from a renter. If you're just going to bail from the unit, you got to give the property 3 days of notice. Be truthful in your application. And if there are any maintenance or repair issues, follow the correct process, like paying rent in escrow, filing a tenant remedies action. So in other words, if a landlord isn't making repairs, you can't just not pay the rent. There's an actual legal process you have to follow to do that. That is all that I have for you today. To log out of today's training, please scroll down below the video window. Find that